recording started. So excellent. Well, you on that side and us on there's a sort of separation, no Berlin Wall in between, nothing of that kind, but yeah. So the other students will follow. I see others that are attending this event from home. So how to begin with? Last week some of us have been in Lyon, and we finished a part of the course which was essentially dedicated to VAT and European consumption tax. We did that because, according to the agreement that Ferrara has with the University of Lyon, we were supposed to begin with VAT. But starting from today, we shall actually address what international taxation should deal with and should deal about. So income taxes, corporate taxes, and the way they are charged when an individual, company, or a business has a trade cross-border in two or more jurisdictions simultaneously. But the meeting of today is in a way informed, because as you can see, I will not present. I will discuss. We can raise questions, and another one is going to talk. Professor Vijnen. Wim Vijnen is a lot of person, even if it's only one. He has been back in time many years ago in the Dutch tax administration. And in another life of his own, he has been the tax treaty negotiator. So he, in a way, was there when a country used to negotiate with other countries how to charge taxes. Then I think that spent most of his life at the IBFD. I'm sorry for my tongue, which is the International Bureau for Fiscal Documentation. It's a non-profit organization based in Amsterdam, in the Netherlands, whose goal is to do research, studies, and more recently also publications in the field of international taxation. It's an open and inclusive research center. It's not a university, but provides a lot of assistance to students, people who want to know, etc., etc., etc. And besides that, Wim Vijnen has also created or initiated an association of tax judges, global association of tax judges, him and other colleagues of his own, where tax judges from all around the world come together and discuss once every year issues, topics, or problems that might arise and might affect taxes in the country. As I used to say to my students, I'm not good at presentation, but I have one advantage: I keep them short. So at least that's the point. It's not the first time here. Of course, they came to Ferrara years ago. But as I told him, one of the good things of coming to Italy is that places are pretty much the same here. Nothing changes because everything is historical, and so the building is the same, the paintings are the same, maybe the books are also the same. So welcome back to your home far away from home. And the idea of this class of today and tomorrow, Wim Vijnen shall stay with us for 2 days, today and tomorrow. So we'll spend, roughly speaking, 4 hours together, little less than that. And my idea was to have like a chat, a talk. I will ask questions. If you want, you can ask questions dealing with international tax, with international taxation, in a way to begin the course in the most gentle way possible. The things that we are going to discuss about shall be sophisticated, will become a little complex, I fear, in the next weeks, but at the very beginning, let's have a look at how international taxation started years ago and what it became more recently. Because we say in Italian, but I think it's also true in English, a lot of water has gone under the bridge, right?
Oh, yes.
In the field of operation taxation.
Yes.
So we can, the others are coming now. No Italian. So, right. So you missed the presentation. I'll do that again. So take a seat and join us.
Okay.
Yeah. Because this event.
We have time.
But trouble's finding the room.
Oh, I'm so sorry. I sent a message, but I should have done it better. So today and tomorrow we'll be here, hopefully. And so, long story short, today we have sort of a round table, an informal moment of discussion with Wim Wijnen, who is he has been a professor of taxation, a researcher, a prominent academic, and back in time a tax inspector in the Dutch tax administration, and the research director of the IBFD, the International Bureau of Fiscal Documentation, in Amsterdam, in the Netherlands, which is perhaps the most important research center in the field of taxation. And to have him back here in Ferrara for me is very important, because when I was a student like you, one of the duties that I was used to have in my university in Bologna was to welcome foreign professor and provide translation from English to Italian, because at that time in Bologna, not everybody was fluent in English. So I was supposed to meet and greet the professor from abroad, shake hands, and translate. And the thing was perhaps the best one I ever had. And the reason why, he is the reason why I do international taxation. I learned so much and a lot from him, from the things that he told me during the classes, from the chat we had in Bologna, in Amsterdam, in Budapest, in all around the world. And that is the point. So the idea for today is to have just questions, comments from you, from me to him, your vision, your ideas about international taxes, and so on. I started this talk like thinking that international taxation is different today as it was in the 90s, when I started translating them for my Bolognese friends at the University of Bologna. Isn't it? Isn't so?
Yeah, I guess. I remember those days very, very well. But a long time ago, meanwhile. I remember that I entered the room for the first time, somewhere year 2000. And then Marco was with me, and I had to explain the principles of international taxation to an audience of 100 people, 120. And, well, I had slides, and I explained the matter in English. My Italian is poor, or perhaps even not really existent. And Marco, the first year, he translated what I said in English. The first hour, I think, sentence by sentence. And then I thought, my goodness, this is going to take quite a bit of time. And Marco understands things so well. So let us now do, let's say, I speak 2 or 3 minutes, and then he comprised everything I said in his own words in Italian. And the year after, well, I had only to mention a term and then the story. So teaching was nowhere so easy as here in Italy with Marco. I had only to say permanent establishment, and then he explained the matter further himself on the basis of the slides. So that is some history about our cooperation, Marco.
Indeed.
And well, about myself, I must say, you see somebody from the past, a voice of the past, some sort of relict. What is for you perhaps prehistory, somewhere in your intuition, it has things happened somewhere in the time of Napoleon or Julius Caesar. But for me, it is just the day of yesterday, what happened in my own life. But most of my work, of course, was in last century, and of course also the last 25 years I was active. But many of the things that we discuss perhaps today about tax treaties and so forth, well, depends on the experience I built up in the course of the years in last century during negotiations and so forth, and further also in judicial practice and advisory. I did I was active in let's say, in all fields of tax law except multinationals. I worked in, first I started as a criminal lawyer in a law firm of my father-in-law for 4 or 5 years. Then I was a tax inspector in the field. I levied income tax of individuals. Then I was for 12 years in the Ministry of Finance. I negotiated tax treaties in that period. I negotiated around 35 tax treaties, also the tax treaty with Italy. If you open the tax treaty between the Netherlands and Italy, well, you see a treaty that I negotiated with my colleagues, of course, because you don't do it on your own with a team. And the team with Italy consisted of three persons, and one of which was I in that period of time. So I negotiated 35 treaties. Some of them were very interesting treaties. Also in the negotiation process itself, with the Soviet Union, I negotiated the treaty with the Soviet Union in 1981, just after Julius Caesar, you could say. And in 92, there was very strong pressure of our businesses in the Netherlands to come to an agreement. So in 2 rounds of negotiations, we had a treaty with the Soviet Union. Also the treaty with China in '86. We succeeded in having the treaty done in 3 rounds of negotiations. So the United States was another story. That took 12 years and only 3 months and round of negotiations. But that was the most difficult negotiations ever. I think not only in the Netherlands but ever in the world, because the Netherlands was seen by the US as a tax paradise. What is not? If you want to know more about it, I can explain that. But the Netherlands is not a tax paradise, what you perhaps read in newspapers. The United States have different opinions about that. They started the negotiations in 1980 with this following sentence of this following idea: how is it possible that the Netherlands is the 3rd investor in the United States? You are with 50 million, and how is it possible that the Netherlands is the 3rd investor in the United States? And then we said, well, we were prepared, of course, for that. They said, well, you are not poor in the Netherlands, but with only 50 million, it is impossible. We said, okay, that is maybe true, but how is it possible that the United States is the 2nd investor in the Netherlands on our list? Well, that had to do with the state of affairs and the domestic law in the United States. So the companies of the United States wanted to arrange their businesses through the Netherlands. It had nothing to do with the Netherlands. It had to do with the domestic income tax system. That the corporate income tax was too high, and they wanted to escape that the high tax rate of 27% in that time. So they organized through the Netherlands.
So you just say that if the tax haven exists, it's because the tax hell and inferno exists as well.
Yes,
so that's the truth.
From the other side.
On the other side.
Yeah, you could say, yeah. Well, it's a very long it was a very long story. Every 3 months we had a negotiation with the United States, and during 12 years, and then in the end we had a tax treaty that was completely different from where we started. To make a safeguarded treatment for Dutch businesses in the treaty, but it became the most complicated tax treaty ever. And the footprints of these negotiations you find today back in the limitation benefits provisions in the OECD model, UN model, and so forth. But everything in this respect, all the abuse rules that you find today in tax treaties, they find their origin in the tax treaty negotiations between the Netherlands and the United States. And we were condemned by the rest of the world when we negotiated this treaty. But when we signed it in '92, before 2000, nearly all countries in Europe had more or less the same provision. Even Italy in a protocol to the treaty with the US, but very simple provision. You didn't follow because of the fact that you said, well, we are completely different from the Netherlands. I had to talk with your Minister Fisco in that period of time. Right?
Yeah, it was in the
99,
probably
2000.
yes, probably not.
Yeah, you had your dual income tax.
Yeah, the DIT, yeah, we call it the
Then you had problems with the United States, and in this respect, whether the United States would give credit for your dual income tax, and then, you said, well, if the trade offers credit in the United States for the dual income tax, then you would accept the rules for abuse as proposed by the United States. Quid pro quo.
So this is a very interesting kickoff. But since it's the first class, I think what is actually a tax treaty, and why does it take so much time to negotiate a tax treaty between two countries? I mean, all the students here, I believe most of them have already taken international law in their home university. So they know what is an international treaty is, an agreement between the two countries where they reach a consensus on maybe on intellectual property, protection of family, you name it. But what are the unique features of a tax treaty? And again, why does it take so long to negotiate? Not because you're lazy, but because...
Yes, that's a very interesting question. If I have to think about it, what is the starting point? I think the starting point is the discussion between the residence state and source state. That is on the basis of any discussion in a tax treaty. Let me give an answer in a wider context. In around 1900, there's tax treaties started. So around 1920, there were a number of tax treaties concluded between states. A tax treaty is always concluded between two states. There's always a state where a company is a resident of an individual, and there is always another country where income is earned by a company or a resident. So there are always two countries involved. And there were around 1920 a number of these treaties. And every country had its own international tax policy. Well, for international business, there was the chance, there was a risk that it would become a jungle of different rules. To avoid that, to avoid chaos for international business, because international business want to have clear rules and simple rules and identifiable rules. So they said, well, perhaps it is good to have a model to create to have as a basis for tax treaty negotiations. So the first model for tax treaties was formulated in 1928 by four lawyers, perhaps tax lawyers. At that period, they were not really tax lawyers, but lawyers, famous lawyers. One from the United States, one from the United Kingdom, one from the Netherlands, and one from Italy. There was an Italian, one of the four was an Italian. And they formulated the first model for tax treaties, 1928. And the idea was to create clarity and to have, for all problems that there were under a tax treaty, to have one solution. But the basic discussion was already in that period of time: are we going to give the right to tax to the resident state, or to the source state where the income is specific income has arisen, or to both. Well, you have the three possibilities: resident state, source state, or to both countries. Well, they found for all types of income that they identified in that period of time. Today, in the models we have today, there are more types of income, but for all types of income that were analyzed in that period of time, identified in that period of time, there was a solution, one solution. But on the basis of the basic discussion, residence or source state. So underneath, there were differences of opinion, but they found one solution. Well, that is the situation in 28. Then, in the 30s, the discussion went on. Should it be resident state or source state? Well, may I give you, what would you think? Where should be the emphasis for the taxation? In the resident state or in the source state? What do you think? If you had a choice.
In the source state.
Okay.
It would be just my guess, no.
Yeah. You say you go for the source state. Who's going for the resident state? So you have a company or an individual. He's living in one state, let's say state A, and there is income in state B. What would have your preference? So out of the blue. It's not a bad idea. Let me be very clear. You.
Well, then I'll say residence state. Maybe because it's also easier for procedural reasons. Because if you know who your residents are in the state, you just tax them in the residence state.
I think I like your idea. The right that is how it was worked out in the model of 28, and still today, the primary right to tax is given to the resident state, and the reason is very simple. Well, in the resident state, you have all the information about the taxpayer. If you take, for instance, the example of a person living in, let's say, in Como, and he works in a pizzeria in Chiasso in Switzerland. Well, in Italy, he is registered in the civil registry. He's known by the tax administration. So all the information about this person or this company is in Italy, not in Switzerland, where the income is earned. This individual, he goes to the pizzeria, he works there 5 days per week, he gets his income, his employment income, and goes back. But in Switzerland, we don't know that much about him. Perhaps he has other income in Italy. So most information about this person and this company are in such a situation in Italy. So the residence state has the primary right to tax. That is how it was in 28, and still today in the, let's say, the OECD model and the UN model. I come back perhaps. So let me now continue my story. In the 30s, there was still the discussion, the underground, and the discussion under the skin about residence versus source state. Then, in 1940, there was a meeting of countries, and in Mexico, well, there was a war, the Second World War. So the industrialized countries were not there. So the focus shifted from residence to source state. There was more income taxable under the model of 1940 in the source state than in the former models. In 46, there was again a meeting in London, and there, after the war, the industrialized countries were again represented, and the focus shifted again to the resident state. So you see, there was always a discussion between resident state and source state. Then, in these models, they played a role under the League of Nations. As you know, the League of Nations were cancelled and they were taken over by the United Nations. In very brief terms, the United Nations didn't take over the efforts in the field of international taxation of the League of Nations, so it stopped there. Then the OECD, the OECD took over and produced, again in very brief terms, a new model, the OECD model. And that model was made for tax treaty negotiations as a model between the OECD countries. Only that, it was focused on just the relation between the 24 OECD members in 63. Today we have 38 or 39 OECD members. But this model is not only a model of 30 articles, 32 articles, and the articles are divided in a number of provisions, and altogether you have 100 to 120 provisions, well, to cover the needs of a tax treaty. This OECD model of 63 is in fact the basis of everything that followed afterwards. It is not only the model itself. The model itself is, you will see it, you can look at it from two sides. You can say, well, it is easy reading. Some the provisions are very simple, readable. However, they have to cover two very complicated domestic laws. And in fact, and you know, domestic laws already are abstract by their nature. Tax treaties are even much more abstract. They are worded in very general terms. And, well, that means that tax treaties need interpretation. Well, the builders of these models, they knew that. The governments who set up this OECD model, they realized that the model itself was not self-evident and that a lot of interpretation was needed. So they made a commentary. And the commentary to the OECD model became, in fact, the Bible of the international tax law. Without the commentary, perhaps you think when you read the model, you say, well, I understand everything, perhaps. But in fact, actually, these provisions of the OECD model are so abstract that they are not really understandable and useful in practice without a detailed commentary. So the model and the commentary are, let's say, a duo, and that, well, forms the basis of international taxation nowadays. The OECD model has adapted not every now and then, but several times. But you can say that the OECD model nowadays, I think, is for 90%, 95%, the same as the model of 63. It is perhaps you could compare it with people who set up the lines of the tennis game 200 years ago. They made tennis, and still the game is made between the same lines. You could say, well, the same happened with the OECD model. It was made in 63. The world has changed since 63 enormously, but still the game is played within the same lines. Well, that is one part of the point. The OECD, of course, consists of industrialized countries.
Sorry to interrupt you since you are talking. But do you think, you said that it's like tennis, so the lines are there, the field is pretty much like that. But this is a positive thing or a negative thing? So do you think that treaties should be changed dramatically in order to address the new economy, digital economy, etc.? Or the point is that they were so well written, I mean, the model was so well written in 1963 that still holds the test of time? Well,
yeah, I think that what businesses want, and perhaps we all of us, also individuals, is stability. And I think, of course, the world changed enormously, but the principle that was valid in, let's say, in 1920, that tax treaties were needed to avoid chaos, I think still today there is an enormous need to structure and stability. But the big problem today is that there are all kinds of ideas, but none of these ideas is able to develop more in the near future because of the fact that there are too many counter arguments available. So I think tax treaties still have a function. Where it goes, I do not know. I am not a prophet. Well, if it comes to predict the future, well, I would say predicting is a difficult affair, in particular if it refers to the future. So I don't know where it goes. I think the lines set out in '63 are still valid today, are still valid also for developing countries, because you should realize after '63 there was by the United Nations an own model was made for tax treaty negotiations between developing countries and between developing countries and OECD countries, and that model gives a bit more attention to the position of the source country. But still, it is a residence-based treaty model. The UN model is not source-based, it is residence-based. It is for 95% exactly the same as the OECD model. So we have two models. One model for the OECD country, which is residence-based. One treaty for all countries in the world, with a specific attention to the source principle, well, to favor the developing countries. But still, the UN model is, again in percentages, perhaps I'm wrong, but I dare to say more than 95% of the UN model is exactly the same as the OECD model. Not only the model, the UN model, but also the UN commentary, the commentary to the UN model. But both, and that is something you should realize, both models are residence-based.
There was a question from the student.
Yeah, so since you mentioned tennis, I was wondering if, as the players changed the way to play tennis over the years, if also the commentaries and people that interpret the treaty changed the way of operating while interpreting the treaties, and changed the way to approach interpretation and treaties.
Well,
or if it stayed kind of the same as.
Well, tax treaties, that's. I see your point. I think, but then again, very gentle. I think that any tax rule declines in the course of its existence by using it. You can so tax treaties are interpreted in many ways by governments all over the place in the world, by the nearly 200. Now, let's say there are tax treaties in 180 countries in the world, and they are interpreted by governments. Many governments conclude tax treaties without the real intention to implement and to use that in practice. The first thing that you see happening in countries after the introduction, the entry into force of the treaty, is that countries try to avoid the obligations that it contains. Further, many tax procedures in courts to interpret the treaty. I set up with some colleagues in and outside the IPFD a database containing all cases dealing with the interpretation of tax treaties. We were nearly, when I gave it to my successors some 2-3 years ago, the database contained more than 10,000 cases all over the place in the world. It was nearly complete. There were 1,000 or 2,000 cases to do. But in all these also Italian cases, also your court in Italy has decided quite a number of cases. But they are all in the database. So all these also court decisions, well, they were interpreted tax treaties in more detail, and whether it is going to decline the treaties, I think the commentary of the OECD model doubled or three-doubled in the course of the years because of exactly that point. And then perhaps you think the more information in the commentary, the less problems there are. No, that is not what the result is. The more text, also in the commentary, the more text there is to be interpreted. Every word can always be interpreted, whether it is in the model itself or in the commentary. So the more text, the more discussion, and the more difference of opinion. So whether it is going to the end of it, in the end of the day, leads to a situation where you say, well, let's forget tax treaties. I don't know. I don't know if that's going to happen in the near future, particularly with AI and all that kind of thing. What you see happening, but I'm not a specialist anymore in this field, is, let's say, a shift from the attention from the income to the person who the income receives. So that is
interesting. What do you mean? So not the focusing?
Well, the models they focus on. No, sorry, I made a mistake. The models focus on the person who receives the income, and the focus is now more on the income, the amount of the income. That is, sorry, I made a mistake. With transfer pricing and all that kind of thing.
Actually, there is, if you look in these days in the journals, or if you watch discussion on television in the evening, there are a lot of people, but also prominent academics, that they say, well, we should tax more high net worth individuals that have their business worldwide. We should ask for them to pay more because they should contribute. On one side, I believe there are two aspects of this one. One, which is intrinsically national, and we can do nothing about that. I mean, how much you are supposed to pay. This depends on the country you're living in. But then there is another aspect, the international aspect of the thing. Under which conditions you can ask a high net worth individual to pay taxes in your jurisdiction, or how can I say that? Does it make sense to make this ultra rich person pay more? But where exactly?
Well, yeah. Also, the OECD and the UN model, well, they are residence based, so the income of these wealthy people should be taxed in the residence state. Let's be very clear. That is the starting point. And if they have income from another country, well, then the other country can, under the rules of the tax treaty, the other country, the source country, can can levy tax. If you say, well, but they try to escape through constructions, taxation in the resident state, well, then we have to do something in tax treaties. And what you see happening now, that the abuse rules in the tax treaties grew enormously. Through a limitation on benefits provision, you formulate a whole set of objective rules to counteract abuse. But there is even now, with the principal purpose test, a new test introduced in the OECD and also the UN model to a subjective test whether the treaty is abused by a certain person. So the number of abuse rules in tax treaties grew enormously, and the focus is just on that in international taxation, the abuse of tax treaties by companies and individuals.
But maybe the students could ask you at this point, how is it possible to abuse of a tax treaty? I mean, you told us that essentially a tax treaty is built, is negotiated, built, and comes into force in order to prevent an adverse situation, which is double taxation. It's built and it's applied in order for a person to pay taxes only once, maybe in one country, perhaps in another, but not in both. It's very simple. It's like plain vanilla, the goal of the tax treaty. So if this is the pattern, if this, very simple and straightforward, is the reason why treaties are negotiated, to prevent car crash, to prevent car crash, how is it possible to abuse of a tax treaty? Which it seems contradictory, or not?
Well, there are many ways to find an escape also by using tax treaties, because of the fact that many terms are very abstract, what I mentioned already. Well, let me give you a clear example. A clear example that started in the early 80s. If a company is incorporated in state A, well, you know what is incorporation. You make statutes. You go to a notary. You make statutes. The notary is doing that. You pay in a certain amount of capital, and you go to the Chamber of Commerce, and you register there, and your company is born. You have a company. This is a resident under tax treaties. Well, but this company can be, if the effective management of the company is in state B, it is incorporated in state A, but the effective management is in state B. Then, well, the income is taxable in state B, not in the state of residence. Well, what is effective management? What is it? There's only a term in the treaty. There's a tiebreaker rule. A specific provision in Article 4, Paragraph 3 in tiebreaker, saying that if a company is a resident of two states, the state of incorporation in state A, and on the basis of the domestic law in state B, on the basis of effective management, well, the treaty says the right to tax the income of the company is in state B. That's what is effective management. Why companies were doing so? Well, for instance, if you take the example of the Netherlands, they incorporated in the Netherlands because of the fact that the Netherlands had tax treaties with 100 other countries with low withholding rates. So by incorporating a company in the Netherlands, they could make use of the tax treaties in the Netherlands. And so they set up on day one, I exaggerate, but without exaggeration, things are not always immediately understandable. They set up a company in the Netherlands, incorporated the company in the Netherlands. They too, they were, the effective management was already in Germany or in Italy. Well, then, according to the domestic laws of Germany and Italy, well, these companies were taxable in Italy. The income that they had, well, was taxable there. But for the other businesses, were arranged through the Netherlands, through the company in the Netherlands. They abused the Netherlands tax treaty network.
So they just pretended to be Dutch in order to
No, not. They were Dutch.
Okay,
They were
sure.
born there. The company was born in the Netherlands. It was incorporated. You cannot say that it is not. You can say we are looking through it. No, it was a Dutch company, and being subject to Dutch tax, because that is the basis of residence. You have to be. You are a resident if you are a Dutch company, and if you are subject to tax. Well, these companies are subject to tax in the Netherlands. There's no doubt about that. The same could happen also in Italy.
Sure.
So, incorporate in Italy,
In Italian.
and then effective management in Switzerland, or the other way around. So, you see it everywhere, and you see this kind of thing you saw happening all over the place. In particular also in the Netherlands, because of the fact that we have a very extreme system, domestic system, for our own purposes. But effective management has been such an issue. So much income was avoided through tax treaties that Article 4, Paragraph 3 was changed. So the tiebreaker rule that made it possible to set up a company in State A with the effective management in State B, the OECD model in 2017 changed. He said the tiebreaker, what they call the tiebreaker rule, if there is a company incorporated in State A and the effective management is effectively managed in State B, that rule is abolished, and it is now in the hands of the two governments. The two governments now decide whether in such a situation the company is a resident of State A or State B. You cannot go to court anymore. In former days, a tax inspector in state could go to court, or the company could go to court, but today, under Article 4, Paragraph 3, the governments, they decide of which country the company is a resident, and if they cannot come to an agreement, bad luck, double taxation. A very hard rule, I would say. Yeah?
So I didn't really get, what was the profit that they got out of the Netherlands? Like, are the taxes way lower than in other countries, or like, I didn't really get that.
Yeah. That has to do with let's say, with.
Well, you said like there are like a lot of like tax treaties, but what does it mean? Like,
I see your
like
point.
a network of tax treaties. What does that get me in the Netherlands?
I can explain that, but that takes 10 minutes.
Okay. Oh, before you can have a
No, that's
break,
good.
because we have normally
I
2
can
hours.
only explain. Yes. No. I
Okay,
can
we
only
can start
explain.
maybe, you can have a break and then continue after
Yes.
the break.
Point is, the Netherlands is very extreme in its domestic law. We have had a very consistent approach of international taxation. We were, in certain respects, we were more or less the center of everything, and we were, let's say, more or less the leading. I don't. Perhaps I exaggerate. Of course, I exaggerate. But the leading factor in this kind of thing, because of our domestic system that was very well thought by our ancestors. But it led to complications. But perhaps it is good to give you the Dutch tax treaty policy, because if you understand that, you see that tax treaty policy relates to geography and to the needs of your own businesses, and depends on the size of your country. So every country has its own legal culture in this field. But the Netherlands was extreme, and there perhaps it is a good example. So I can explain that. Tax paradise, yes, you can say that. There are so many companies that in the Netherlands active and still are, that are not really Dutch, that they are only a foothold for investors outside of the Netherlands. Yeah, that's
So just for your knowledge, a tax paradise, a tax haven is a country that allegedly provides remarkable tax benefits in
Yes.
terms of low taxes, rate, or other.
yes, but there you touch really the dividing line between a tax paradise and a country that has. The point is, none of these rules that we have in the Netherlands are made to attract foreign business. Of course, we need foreign business investments from outside, but only for ourselves. But it was never meant. We never made rules to create the facilities for foreign investors to make use of the Netherlands to get income from other countries. That the third step was never part of our Dutch tax treaty policy. What we have on international taxation was needed for ourselves, not to create a foothold for international external businesses. But let me explain it then.
Sure, of course.
Yeah, if now or
Oh,
it's,
well, actually, if it's fine with you, we can have a 10 minutes break now, and then we will continue with the explanation later, because we do 2 hours normally, but then break in between.
okay.
So now it's more or less 3 p.m.
Yeah.
Time for coffee, for water, for you, and then we'll continue from this point with the answer to that question.
Yeah, because I think we addressed.
Yes, absolutely. It is. It is. If you want to go and grab a coffee, we'll stay here and we'll see
What I'm a bit